So the Fifth Circuit on Tuesday of this week, that's 2 days ago, upheld injunctions barring, this is crazy, barring the National Labor Relations Board from prosecuting unfair labor practice charges against three companies, saying the removal protections that federal labor law gives board members and agency judges likely violate the U.S. Constitution. So this is not just applying in Texas. This could have much broader implications. These three companies, including SpaceX, had sued to block the National Labor Relations Board cases against them based on what they characterized as unconstitutional limits on the president's ability to fire board members and administrative law judges. So this is really a huge decision. The arguments made in the case really hinge on language in the National Labor Relations Act that only allows the president to fire board members from office before the end of their 5-year terms for, quote, neglect of duty or malfeasance in office. The president can also only remove the agency's administrative law judges, quote, for good cause, end quote, after a hearing before the Merit Systems Protection Board, the leaders of which also have removal protections. So, Jim, what does this mean for employers facing unfair labor practice charges in front of the National Labor Relations Board right now?
Yeah, I think it's a little early to tell right now, Phil, what's going to happen, but it certainly like potentially cuts the legs out from underneath the board, right? And it's amazing to me that the NLRA has been around for 90 years. It had challenges to its constitutionality right from the get-go that survived. And we're just sort of dealing with these new theories of the law. And it's amazing how the interpretations of the law changes. But it all goes back to this unitary theory of the executive, right? That SpaceX was sort of pushing a couple of years ago when they started this, and then President Trump has adopted. And so for the viewers out there, I think everybody understands that certain agencies, the State Department, Treasury Department, Department of Defense, those folks serve who are in charge of those agencies serve at the president's pleasure, right? So a new president comes in, we got a new Secretary of State, new Secretary of Defense. But then there's these other agencies that exist within the executive branch, like the NLRB, like the EEOC, like the Occupational Safety Health Review Commission, like the National Mediation Board, that are these sort of made up of multiple members, multiple commissioners that Congress has set up. And SpaceX, made this argument, and President Trump has been making this argument in the Wilcox case, saying, like, hold on a second. This violates the separation of powers. If these guys are in the executive branch, they should serve at the pleasure of the president, right? And you can't have all these like multiple layers of protection for removal of these folks, right? So because it would violate the separation of powers, right? It violates the president's authority to operate the executive branch. So it really sort of dovetails with this Wilcox case that you mentioned, Burt. Ultimately, I think that the Supreme Court, with the members anyway, with the board members, the Supreme Court is gonna decide that. I guess they're should chime in on the ALJs, but I don't know if the Supreme Court's going to already say, hey, between SELA law and JARCASI, we've already sort of called into question the ALJ sort of format. And that goes to other sort of areas too, like, right, if the administrative law judges exists, I mentioned some other agencies, but administrative law judges exist in all sorts of fashions and formats within the federal government, like hearing Social Security appeals, for example. Depending on how the wording of how they're created, this could sort of be like pulling a thread on a sweater, right? And all these,
Right.
not just the NLRB, but what happens at OSHRC, EEOC. Of course, details matter, right? The statutes matter. But this could be an interesting development in how particularly these multi-member federal agencies and ALJs are set up.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deacon's top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.